guest, Rick Esenberg of the Wisconsin Institute for Law and Liberty. It's a double Will whammy on the Vicki McKenna show today. Corey Brewer, you may remember, was just on the program talking about helping parents whose kids are bullied. Rick is on to talk about the big abortion case that is going on in Dane County. Rick, welcome to the show. Good to have you.
Well, thanks for having me on.
What's the case? How does this case actually work? And this is what we've been hearing. Everybody says 1849 law. Well, but the law has been amended multiple times, and to make Wisconsin compliant with Roe versus Wade when it was still the law of the land, as I understand, an additional law was passed. What is going on? Is Kaul arguing that the law that was passed was a repeal? Or how do these work together? With this old law, this new law, and a bunch of amendments?
Yes. So what he's not arguing, as far as I know, is that there is a constitutional right to abortion under the Wisconsin Constitution. That would be a difficult argument to make. There's nothing about abortion in the U.S. Constitution. There's nothing in the Wisconsin Constitution either. So what he's arguing, and I think his principal argument is that the later passed law implicitly repealed the older law that was originally passed in 1849 when Wisconsin became a state, but has been, as you pointed out, amended several times since then. And I say implicit because if you read the later law that was passed in the 1980s, it doesn't say that the old law is repealed, and it quite clearly was designed to impose a set of restrictions on abortion that would withstand the rule of Roe. They were, what Roe would permit. And they quite intentionally did not go back and amend the earlier law because they intended for it to stand. And that's a problem for the Attorney General because implicit repeal, it exists, it can happen, but courts say it's highly disfavored. And it turns on the intent of the legislature. The legislature actually intends to do that. And I think it's quite clear in this case that that's not what they intended. What they were trying to do is have some restrictions that could be in place as long as, Roe was good constitutional law. And now it's not.
Okay. So is there a record of the legislative discussions in the 1980s when they passed the Roe compliant law?
Well, I mean, you could go back and you could look at the debate. I don't know that you even need to get that far because if you look at what they did and how it's structured, it quite clearly is a law that's designed to be compliant.
This is a Dane County court. I'm just thinking maybe you should dot your I's and cross your T's.
It's not our case, but absolutely they should dot their I's and cross their T's and make as strong an argument as they possibly can. And I trust that is what happened.
So he's trying to say that a later law implicitly repealed the earlier law, except. And I understand this was 2011. So it was fairly recently that the legislature, I think, and I believe it was the original law. Tell me if I'm wrong. It's very confusing when you start getting into all the amendments. So that there was no penalty for the woman under the original existing Wisconsin statute.
Right. That was in a separate statute. And once again, you see. This is further evidence that the legislature did not intend to repeal the old law, because typically, if you wanted to touch that law, what you would do is you would go directly to the law and you would amend it. You would change its wording. Now, they did this in a separate statute. Why did they do it in a separate statute? Because I think that they passed this in an appropriations bill, and at the time, the governor had this strange veto power where it could strike words. And so, I don't think, Walker was, it was 2011, Walker was in power, but I think that they wanted to do this without disturbing the old law in some way. And so, that's the way they proceeded.
Well, okay. So again, more evidence that the intention of the law that Kaul is challenging, the intention wasn't for that law to repeal the original law, because if Roe ever got overturned, Wisconsin would default back to that original statute.
Right. And they made very clear in the law which repealed these criminal penalties, they intended to do that notwithstanding any other law that might be in place.
I was listening to you, and it was a very, very awesome conversation on the WRN podcast just a couple of weeks ago. You had mentioned that Kaul is also potentially trying to argue that the law is just so old, we should just get rid of it. Can you do that?
Well, you can find some examples where something like that happened, but what tends to happen with a law that, was passed a long time ago, and then it never gets enforced, and nobody ever thinks about it, right? So you'll find an old law that regulates who can sell buggy whips or something like that, and we don't have buggy whips anymore, and so nobody has thought about this for years and years and years and years. And maybe you can make that argument again, although again it's pretty rare that would be successful. But I don't think you can say that with respect to abortion and the fact that the Wisconsin law prohibits abortion. Everybody was aware in the post-Roe period that old statute existed. I mean, there was a lot of ink spilled over about what would happen if Roe ever was overturned. I think I wrote a paper for Wisconsin Right to Life on that many, many years ago. And so this was not an obscure law that the legislature had forgotten about. And so the fact that it was there, they knew it was there, they didn't repeal it, I think makes that argument a complete non-starter.
All right. So what now, in the way this is proceeding, how long is it expected that both sides are going to be presenting in the court? How long would you expect the judge to take to render a decision on this case?
Oh, well, when you look at the amount of time the judges take to render a decision, I mean, it varies dramatically. I mean, there's a lot of times when, cases will just sit there and the judge will be working on it and you don't hear anything. And, there's an old saying among lawyers that, when the judge isn't issuing a decision, you want to be careful about asking for one because you might get it. And maybe you won't like it, and maybe you won't like it because you bothered them. I don't think most judges would do that consciously, but it's kind of a joke that lawyers tell each other, and legal humor, not that strong. And so so it could take a long time, or it could be very, very quickly that the judge enjoins the law, and in that circumstance, there might be a more or less immediate attempt to take this case up to the Wisconsin Supreme Court to bypass the Court of Appeals. And it perhaps is unlikely, but it's possible that the issue could get to the court prior to the time that its personnel changes, because Justice Rogenstack is still on the court through the end of July this year. And it's on August 1st that the new term begins, and Janet Protashewicz takes a seat on the court.
Is Kaul asking for an immediate injunction?
I think he is. Because I think one of the issues in this case is, and one of the arguments that I understand is being made by the defendant is that Kaul really can't proceed with this because neither he nor the other parties to the case have been harmed because nobody has been prosecuted under the old law. And his response to that is, well, the problem is that, the state and people who are interested in the availability of abortions, they need clarity, right? They need to know what the law is so they can proceid, and that this is the
law is pretty clear. The law is pretty clear, isn't it? Seems pretty clear to me.
Well, I would agree with you, but the AG's position is that no, there was this implicit repeal, and it's not, and people that want abortion to be available, need to know that, even though nobody has been prosecuted. There's also sort of related issues. Courts are generally very reluctant to interfere with prosecutions that haven't happened or haven't been brought to conclusion. There are separation of powers concerns there, and so that's another issue. That's a little bit more inside baseball, but
well, that's interesting though, because and all of us, as you're talking, say, well, this is a pretty weak case, except it's in Dane County. If this were in another county in Wisconsin, who knows? This decision might come down quickly. Maybe it will come down quickly. Maybe it will come down later. But just based on the argument or the logic that you are presenting, it seems like logically and legally, the side, the winning side, you'd bet would be the state of Wisconsin's original statute.
Yeah, well, and I think that's right. But I've been doing this long enough to know that predicting the outcome is
yes.
difficult.
Well, right. I'm saying if this maybe were in, I don't know, Fond du Lac County or Waukesha County, things would just be a little bit different in terms of people's, willingness to predict the outcome of this particular case. So the entire argument is resting on whether or not a judge is willing to kind of ignore that general disinclination they have to violate separation of powers, and is willing to ignore legislative intent. That seems like what you're saying.
Right. What I am saying is that I think that the defendants have the better of this argument on a number of grounds, and we'll see whether the judge agrees. I wouldn't prejudge that, but that's what we have lawsuits for.
Yeah,
arguments get made and decisions get made,
and no guess on the timeline either, none, because like you say, so there's a argument that the judge might slow walk it. There's an argument that it might be quick. Just no way to guess. Rick Esenberg, thanks so much for joining me on the program and walking people through that, because it's a lot different than what you read in the paper.
Well, thanks for having me on.
Always great to have you, Rick.